Welcome back to Truth to Power podcast on Danger of Autos, and as always, I am joined by Mariel Manassi, the Executive Director of New Energy Economy. How are you doing today?
I'm good to be talking to you.
I'm glad to be here with you. We've had a lot of huge updates, just I think in this week alone, haven't we? Like a lot has happened with New Energy Economy. I feel like there's a lot to talk about. Let's start at the beginning. There has been a rate credit situation, a huge update with the PNM Rate Credits issues. If you're unfamiliar with it, I encourage our listeners to go back and listen to the previous couple of episodes. But we've gotten some significant news with the rate credit. You want to tell us a little bit about that?
Yes, please. PNM drafted the Energy Transition Act and also the financing order that was required to be drafted pursuant to their request to abandon San Juan Generating Station and get what's called securitized financing, so that they would basically issue bonds to cover them for their what's called undepreciated assets, or more commonly known as stranded assets, what was still allegedly left owing by us to pay them back for San Juan. And there was a deal made, and the deal was you close coal and we will give you all of your stranded assets. That was sort of the big picture deal that the ETA represented. And the securitized bonds were, and this is a quote, to be issued shortly after the abandonment of the plant on July 1st, 2022. But that's not what happened. PNM didn't do that. And they were supposed to do that at the same time as begin giving us credits so there was, at the time of abandonment, which was in 2022, Unit 1 in July 2022, and Unit 4 on October 2022. And they were supposed to do two things: give us a credit, meaning stop charging us for San Juan because we were no longer using it. And two is issue these bonds. They did neither. And that was required in the financing order. It was black and white.
That they helped write.
And they didn't do it. So there was a promise that they, a contract is essentially a promise, and that they were going to do these things, and then they didn't follow through. So at first, last summer, led by WRA, I'll just say, Western Resource Advocates, filed a petition to show cause, it's called, to say, hey, this is their plan. They're not going to issue these bonds. They're not going to issue the rate adjustment that we were supposed to get. When the plant closes, they're going to continue to charge us as if the plant were operating. So these were phantom costs at this point. They weren't incurring any costs for the plant because the plant was shuttered, but they were charging us as if it were still continuing. That amounts to approximately $98 million per year. And so we had what's called this show cause hearing, and we won. And basically, the hearing examiners found that PNM violated the ETA and violated the financing order. The commission upheld that and said, issue the credits immediately. They started to. PNM started to issue the credits. But then PNM appealed to the Supreme Court and then got a stay. And a stay is basically, we want you to forbid the PRC's order from taking place. And so we were pretty upset about that, that the Supreme Court did that. And we filed a motion to reconsider their decision, but we lost. And then what we found out was that PNM wanted to settle the issue because, frankly, they couldn't issue their securitized bonds while there was this cloud hanging over the bonds,
right?
The bond issuance. And so this was the first time that New Energy Economy ever engaged in a settlement with PNM. And it wasn't perfect. Perfect would have been that they would give us the rate credit plus interest and a penalty. That would have been really the appropriate thing to do. But we negotiated, and we've got them to issue a full rate credit. And it's pretty remarkable, I will just say, because so that $98 million a year, they're going to start paying us back on our bills every month within 30 days.
Wow.
And it's the average ratepayer will get a refund of $9.28, about 11% of an average bill that we have in New Mexico. So it's pretty significant, and I think it's pretty significant not only in terms of the amount of money, but that it's a complete refund. And also, where in the United States have you seen a utility having to refund customers of this magnitude?
Almost never. Yeah, this is unheard of. I say almost never with some sort of confidence, like I have heard of it before. I've never heard of it before.
I've never heard of it before either. I mean, I've seen that there's been some refunds, but usually it's like cents. Mm-hmm. This is a big deal, and so I think that when PNM ratepayers, about 40% of them live at or below the poverty level. So this is a real savings for people, and especially the most vulnerable. And so we're proud to have engaged in the settlement process and then won. And what was really also important was that the day before our defense of the Avangrid merger appeal in the Supreme Court, at around 4:00, the Supreme Court granted, it was a motion for remand to the PRC to accept the settlement. And what was very important about that was, it was like, I took it as an omen, that it was a good sign that the Avangrid hearing was going to go well, which I think it did go well. And I think what was also really interesting and important about it was that the refund is about $9.28, as I said before. And what Avangrid was offering ratepayers was $1.64 a month. And I think that it wasn't lost on the Supreme Court justices, the juxtaposition of what Avangrid was offering as a way to come into the state and merge, and what we have just won, and people will be seeing literally any day now on their bills. So I hope that was significant in their minds, and I think it was.
I see what you're saying, because when it comes down to these monopolies, there has to be some sort of demonstrable net benefit to the people who are subject to these monopolies. And in the case, like you mentioned, the Avangrid merger, their supposed net benefit is nickel and diming, while in the meantime, you are winning for ratepayers in New Mexico
a much more significant benefit, a real benefit, like not $1.64.
Like the equivalent of a big budget movie, just spread between everybody who's a PNM ratepayer. So that's significant. You mentioned the merger, and we could pivot to that if you're ready to talk about that. I was there. I had the privilege of watching Mariel speak before the Supreme Court of New Mexico, and it was very cool. And why don't you tell me about that experience?
Well, I think that one of the most profound parts of it for me personally was that I had real engagement with the justices. I was talking to them pretty much the whole time. It was like a dialogue, and I was looking in their eyes, and I had prepared remarks, of course, but when I got up to speak, I sort of ditched them, and I just said, "You asked some questions, Justice Thompson or Justice Bacon or Justice Vargas, and I'd like to answer them." And I took them literally one by one. And, I was involved in the hearing, and the other two lawyers who argued were not. And so I had a grasp of the facts and also where in the record those particular facts remain. It's called a record proper cite. So I could very, very, I had these listed in my notes. I didn't know exactly what the justices were going to ask, but I had a number of different points and record proper cites to point them to. So I think that they were impressed by that. I think that they were engaged with me. Like, I felt a connection, that there was true interchange. And I hope that I answered their questions. And their questions were mainly about a couple of things. So I'll tell you I think three things. One was there was a report that was done in Maine, which was a scathing report, and it detailed the poor performance of Avangrid there, but also in New York and Connecticut as well. But it mostly focused on Maine. And the most scathing thing that it said came on page 4 of the executive summary. And it said basically that Avangrid and Iberdrola are so focused on their profits that customer service takes a hit, and that's really the result. That's why their performance is so bad, is that they have sacrificed professionalism and just service for their interest in making money and getting that money quickly to shareholder investors. It also talked a lot about the undue influence of Iberdrola, which is an 81.5% owner of Avangrid. And it says they warn in their SEC, Securities and Exchange Commission filings, Avangrid warns investors that their, meaning investors' interests, may not be aligned with Iberdrola's interests, and Iberdrola is a controlling party owner of Avangrid. And that is exactly what this report said. I think those are the two main points of the report. I mean, it details, it's 130 pages,
right,
of problems with service and poor performance. I mean, everything from, not having enough customer service agents to not doing tree management. And tree management is very important because obviously one of the biggest wildfires in the U.S. history was started from an electric pole catching fire.
Right.
In California. So this is, vegetation management is what they call it. But, so it ran the gamut of inefficiencies and incompetence and unprofessionalism, including things like really the service people not being well informed and prepared, whether that's answering phones or connecting service, or a whole host of things. But they said the reasons is because they were too focused on making money and the investor profits. And the second thing was that Iberdrola was calling the shots, and it wasn't being called by the local engineers and professionals who were supposed to be in charge of the subsidiary utility, which in Maine is Central Maine Power. And so this was an issue at our hearing, which was local control. Is PNM going to be controlled literally by Iberdrola, and what Iberdrola wants to have happen, as opposed to what the current engineers and professionals and at PNM think it should happen. So the lawyer for Avangrid and PNM argued that report should not have been entered into evidence, and said that they had due process violations because that there was a due process violation because they couldn't cross-examine the authors of the report.
Right.
So we countered with a couple things. One is reports of another commission can come into evidence. That's totally fine. The other thing is also fine in administrative agencies is to allow what's called hearsay, which is precisely like this report. But also, more broadly, the question was quickly squashed by the court, I think, because this is exactly the kind of information that you would want to know if you're considering as a commission to allow or not a company to merge. It's like, I think that we discussed this before. If you're a college admission counselor, you want to know what the person's grades were in high school. If you're a landlord, you want to know where the renter has lived before and what's the employment of the renter. If if you're going to go buy a car, you look under the hood. It's like doing your due diligence. If there is another commission where this utility is operating, you want to know how that other commission finds the performance of that utility. And that was quickly dismissed as a non-argument, I think. And they had this good law, but it was completely misapplied, which was called the legal residuum rule. And there's a case in New Mexico that says you can't base a decision on hearsay. But you can allow hearsay into administrative agency hearings and cases.
Meaning that this report that you're talking about, this technically hearsay report, if the PRC had rejected the merger just because they read that report and that was it, and they wiped and they're one and done, looks good to me. Farmer Brown said Avangrid's no good, we're going home. That would be against the law.
Exactly.
But if that hearsay evidence corroborates what you call a mountain of actual evidence, then the legal residual rule clearly states that it's fine, right? Exactly.
And that is what the justices basically said. And that was a pretty important moment when Justice Bacon, the Supreme Court Chief Justice, said, I disagree with you. There is, and she said the word overwhelming evidence. And when she said that, I thought, wow, we might just win this case.
Right.
Because there was overwhelming evidence against Avangrid. So that was the legal residuum rule and the audit in Maine were two issues. Or the legal residuum rule was sort of like the meta issue, and then
right.
The audit came underneath that. And then there was another one, and they objected to a criminal investigation that was pending at the time for the commission to consider that. And the law is that you can consider a criminal investigation, but you can't presume guilt.
Right, because everyone's innocent until proven guilty.
Right.
Along that.
And so there was a remark pretty much by one of the commissioners that called Iberdrola's acts illegal acts. And so the court asked me, what do you think about that? Isn't that presuming the guilt? And I said, there's no question that the criminal investigation should come into evidence, which it did. There's also no question that it influenced the commissioners. But was it the basis? Was it the deciding factor? Was there nothing else besides that? And I think the answer is that it evidenced, like you said before, a pattern of misconduct, that this was not an isolated incident. And so we said that we believed that it was proper and that there was no error there. And then the last thing was when there was sanctions that were issued against Avangrid by the hearing examiner for failing to abide the rules of the commission and specifically the discovery rules. And when it was upheld by the full commission, the commission's order said sanctions against joint applicants and didn't say the word Avangrid. So instead of it saying Avangrid as it should have, it said joint applicants. And so the justices were troubled by that. And I think it was a mistake. I don't think it was I don't think it was harmful, though, because I argued, first of all, they applied together, they filed everything together, they knew what was happening. And I also pointed out, again, pinpointed with a record proper site, that, in fact, PNM knew about some of these violations and fines, but consciously made a judgment call not to provide that information to the commission. So even though Avangrid didn't commit it itself, Avangrid was the violator, PNM knew about it and decided, hey, we're not gonna provide this information to the commission, which the commission and the hearing examiner in particular found extremely problematic. And I said it was akin to joint and several liability, that they both made this decision, and it wasn't just Avangrid, even though it was Avangrid's acts that were the heart of the matter. So I said it was harmless error. I said if it was error, it was harmless error. And harmless error means that, yes, there was a mistake, but it shouldn't be of large enough proportions to overturn this correct finding to reject the merger by the commission. And so we'll see what they do. We'll see if they remand. We'll see if they uphold it. Of course, that's what we want. Or if they remanded just for to correct that one order, to say Avangrid as opposed to joint applicants. I think that it went well, and I think that there was one clue, and that was that Justice Bacon said, are we going to send it back to this new PRC? And that was one of my favorite moments, because I think that they were very troubled with the whole ex parte chaos, really. I don't know what else to say. It was like press chaos, because they were engaged in communications with one side of the case and didn't include the other parties. And so I think that the Supreme Court was not happy with the PRC's actions.
So if they uphold it, if the Supreme Court upholds it, that means the merger is dead. But if they remand it, then the PRC gets to redecide. And I guess you're saying that the Supreme Court sounds like they're aware that if they remand it, that they might be sending it to a troubled, chaotic PRC that might be influenced unduly.
Yeah, I think that they also might realize that if they did, I mean, this is still open. Of course, we have to see the opinion, but if they did remand it and it was exclusively for correction of that order, we have to decide if we're going to move to disqualify this commission because of ex parte that they engaged in, because it was in this case, in the merger case, that all occurred.
Right.
And so are they fit to judge, really, that's it, right? Judge this case, even if it's just an administrative change. So we haven't come to that. We have to look at what the opinion says. But maybe they won't send it back, and then we don't ever have to face that.
If it were to be remanded, what kind of faith do you have that the PRC would strike it down or do the right thing, I should say?
I think that they will do the right thing, but it depends on really what it's about and what the order says. If it's just really tailored just to correct that one mistake, I think that they'll just reissue the order and write Avangrid and not joint applicants. If it's more and they say, we're really troubled that the commission considered the guilt of Avangrid and Iberdrola, then we want you to reconsider this case without the information from the Spanish court. That we'll have to see about that, and I don't know if I feel as confident as I would if they just remanded it to change the order.
Okay. And they're worried about this because in the initial decision, the PRC, they, much like Supreme Court justices, write out opinions, correct? And in the PRC's decision on the merger, which is being contested right now, they did not explicitly mention either the hearsay or the criminal investigation. Is that true?
No, they did. They didn't mention the audit report. In their final order, they talked about that the risks of an Avangrid merger outweighed the benefits. And they said that reliable service and performance were at the top of their decision making, and that they were really concerned about the inability of Avangrid to provide basic services, electric utility services. And what are those? Obviously, provide energy for people and bill them for the use of that energy. And Avangrid's subsidiaries have failed miserably in both those regards in all states that they operate. And so that's really the heart of the recommended decision, which is 400 and something pages long, and also the final order. But they didn't mention the audit in the final order, but they did mention being concerned with the Spanish investigation specifically. That's all they said there. They didn't talk about that they presumed that Iberdrola was guilty,
right.
but
just that it was concerning.
That it was concerning, and one of the factors when they decide on a merger is the qualification of the proposed merging entity, and so the hearing examiner, I think, rightfully found that this goes to the character and qualifications of that merging entity, and they are accused. And he said, it is alleged. He said that repeatedly. It is alleged that they've cooked the books, that they forged documents, that they were engaged in bribery and other very troubling matters. And some of those things they have also been accused of and admitted in Maine. I mean, in this case, they said, yeah, we followed environmentalists and we had investigators go out after people who opposed our plans. And the CEO who testified in our case said, yeah, we would do that in New Mexico if we had to. So some of the tactics, even though they were legal, were troubling and part of the qualifications and the character that was discussed by the hearing examiner.
Okay, so that's a pretty big one that might be, I guess our fingers are crossed that they uphold it, and but it sounds like the PRC might not be a completely lost cause. We had an interesting LNG case before them just the other day, I understand. If you're ready to pivot to that.
Yeah. No, I don't think that the PRC is a lost cause. Actually, I've been pleasantly surprised by, in particular, Commissioner Ellison and his involvement and engagement in the PRC rate case, which we were involved in for the last 3 weeks, and Aguilar as well. Not as involved as Ellison, but definitely impressive. So that was kind of reassuring,
yeah.
And I'm pleased. But the thing that we already know just happened was really fantastic, and that was that PRC staff and PNM Gas Company, New Mexico Gas Company, arrived at a settlement allowing for the LNG storage facility in Rio Rancho. And all other parties opposed it. And it's not a numbers game. I mean, if the settlement was correct, then it's correct. But I don't think it is correct. So it's not like just because more people opposed it, it doesn't mean that it did or didn't have validity. But in this case, New Energy Economy, the Attorney General, Western Resource Advocates, and Coalition for Clean Affordable Energy all opposed the settlement. And within 5 days of a settlement being filed with the PRC, other parties have to issue a statement about whether they support it or oppose it, and if they oppose it, why they oppose it. So we did that. We said that we opposed it. We opposed the settlement, and we opposed it because we said that the risks outweighed the benefits. We said it was not cost effective, and we asked them to reject the stipulation, the settlement, out of hand, reject it, and hold a hearing on the merits of the proposal, and we won. And that was led by Ellison and Aguilar, and actually Commissioner O'Connell voted against it. So I was really pleased with that decision. And I think that, Commissioner Ellison said something like, I don't see that this settlement is anything too different than the application. And that was correct. And, usually there's a settlement, there's supposed to be a compromise of some sort. Mm-hmm. But I think what he was basically saying is, what is the benefit to the people as a result of this settlement? And, he voted to reject the settlement. And so we will be going to a hearing on the merits. And there's some very concerning aspects to this LNG facility. And the top ones are, it's not cost effective. No. It's not in a remote area. It's in a populated area.
Right. Their application says it's unpopulated, but it's right next. It's like sandwiched between Ventana Ranch and Dead Eagle. What's it called? Desert?
Double Eagle.
Double Eagle Airport.
Yeah.
And both of those places have plans for expansion, but their application said it's unpopulated, so that's interesting.
Right. And there's like 40,000 people who live in the direct vicinity.
Right.
The other thing is, and location matters with these plants, because there could be a huge disastrous explosion or fire. And basically what happens is it's gas that's cooled to 260 degrees below Fahrenheit. And the advantage of that is to store more gas in a liquefied form. And then they basically reheat it up when they go deliver back into the pipelines to take to people's homes for heating. But the problem with it is that if it leaks, which it will leak, everybody says it leaks, the question is, how much does it leak? And if it leaks enough, then it forms a low-flying vapor cloud, and it like is hunting for a ignition source.
Right.
And if it does ignite, then a very serious explosion could happen. And some people have referred to it as a fireball. And basically, firefighters can't put it out. They have to wait till it extinguishes.
Right.
And so that is extremely scary. And also, there's a couple of schools, a high school and middle school, really close, within 4 miles or 3 miles of the planned facility's location. And so none of these things make sense. And the other part of it is that the gas company is saying that they want to include truck transport of the LNG. And that's also a recipe for disaster. I mean, I-40 and I-25, obviously, those are very well populated, especially right there.
Right. We're going to turn it into a virtual pipeline for methane. If you look up virtual pipeline methane on Google, all you're going to see is news stories about them exploding and causing problems and mass evacuations all over the country. So that's kind of like a major issue there.
Yeah, I mean, there was an LNG facility in Louisiana, and people were on lockdown for 2 days, and that was just in June of this year. So this is a really big concern. All the literature and the experts say it's got to, if it happens at all, it's got to be in a remote area. This is not a remote area. We don't need it. That's the other part of it. So it's not only that it's costly, but it's not necessary. Like, we already have a way. I mean, we're sandwiched in between the San Juan Basin and the Permian Basin. Getting gas is not a problem. Right. And so to create a whole new facility when we're supposed to be decarbonizing, not investing in more fossil fuel infrastructure, is a bad way to go. And then ultimately, the owners of the New Mexico Gas Company is a company called Emera. EMERA. And if you just go to their site, like basically on the front page of their site, they say, and this is the game with all of the utilities, which is to invest in more capital infrastructure because they get a return on equity on that. And that means essentially a guaranteed profit. And right now, the guaranteed profit in rate for the gas company is 9.375%. And so whenever they build something big, like this plant, which they say is $180 million, they get essentially a 10% profit year after year. And that's why they're doing it. And because we already have a solution. Reliability is not a problem for the gas company. And so it's really about investing in capital expenditures so they can get the return on equity, so that they can feed their hungry Wall Street investors. And it's at our expense. And so is it worth it? I don't think it's worth it. I don't think it's necessary. And I think it's contrary to our climate and environmental goals.
Right, because my understanding is during Winter Storm Uri, we didn't run out of gas. The prices of gas went through the roof. So they're kind of proposing this solution to a problem that doesn't exist. It's like, we'll just build a bigger tank, and whatever happened back in 2019 won't happen again. It's like, well, that's not what happened. It's the market. And so one way I've had this explained to me, I think, was since the cost of the facility is well over, $130 million? $180 million. It's a $180 million insurance policy to cover a risk that is in the tens of millions. Because the problem with Winter Storm Uri caused this maybe $30-40 million problem, but they're proposing this $180 million solution. And whenever you explain it about the capital investment and the return on equity and all that the clouds part, and it all makes sense. They're like, oh, the more they spend on this junk, the more they can reward their shareholders. And again, like you said, the website and with Avangrid and with Emera, their goal is not making tasty cheeseburgers and making people happy. That's not what they're in the business of. Their business is in padding the wallets of wealthy investors who don't even probably live in New Mexico, people who don't even, maybe never been here.
That's exactly right.
Fascinating.
Yeah. And so this is not about the performance of New Mexico Gas Company. And it's not about eradicating the vicissitudes of the market, right? It's not going to impact price volatility. If it is at all, it's going to be negligible. And I'd rather have a real good contract with their current supplier than, which they don't want. They don't want a really good contract, because that will cost us less. And it's really for the listeners to understand, the more they spend, the more they make.
Wow.
And that's the point of this whole, it's a boondoggle.
So the rejection of the stipulation means that there is no LNG plant automatically approved, that we get to have a hearing on the merits just like normal people and talk about the cost-benefit analysis.
That's right. And so, our position is it's not cost-effective, it's not necessary, it's antithetical to our climate and environmental goals. And we want to move towards decarbonization and the electrification of even heating, certainly of cars, not invest in more fossil fuel infrastructure that I think will ultimately end in stranded assets again.
It's like I believe the UN Secretary General just said, if I can't quote him directly, but loosely he said, if you were still investing in fossil fuel infrastructure at this point, you're operating in some sort of immorality and idiocy, because everything you construct is going to be worthless within the next 10, 20 years. And these things are supposed to have lifespans
of 40 years.
Of longer than that.
Yeah. And he said also, we're in the era of climate boiling. And so this takes us in the wrong direction.
Yeah. There's an urgency here that I think can be appreciated. So that's great. We have this hearing coming up on LNG, on the cost benefit, and we have a Supreme Court decision coming down on the merger pretty soon, and we have this really amazing rate credit going out to PNM customers. So it's been this has all been in like a week, right?
This is 1 week. Yeah.
That's amazing.
Yeah, pretty good week.
From all New Mexico ratepayers, thank you. And because I know I'm a ratepayer, so I'll see that $9-10 on my bill for the next
year.
And I'm sure everyone out there understands that we would appreciate that. So that's a really cool victory. And everyone stay tuned for more developments. You can visit newenergyeconomy.org for constant developments, and follow us on social media. We have a TikTok now, New Energy Economy, as well as Instagram and Facebook. And thank you so much, Mariel, for your time.
Thank you.